Because I thought we were at the other end of the annex. Do as I say, not as I do. All right, I call the meeting to order. First meeting of the Senate Judiciary Committee. Glad to have everybody here. Madam Secretary, would you please call the roll?
Senator Berg. Senator Carroll.
Here.
Senator Deneen. Here. Senator Neal. Senator Schickel.
Present.
Senator Stivers. Senator Storm.
Present.
Senator Turner.
Here.
Senator Wheeler.
Here.
Chairman Westerfield.
Here.
Looks like we've got a quorum. All right. Seeing that we have a quorum, we're authorized to do business. We'll jump right in here. We're going to go a little bit out of order to accommodate some editing we need to do on one of the bills. I believe you all, correct me, Roberta, if you're in the room. Was the sub distributed, the wrong sub, or just one that didn't go statute through it, so it wasn't sent at all? Okay. So we're going to have a committee sub on Senate Bill 9 that makes some modest changes, but we'd like to do that this morning. They're running that through statute revision right now, and it was not sent and distributed in error. So apologies for that. So we're going to skip over Senate Bill 9 for the moment and go right in. If you're ready, Senator Wheeler, we can take up Senate Bill 40. That's right. Members, this is familiar territory, having heard this bill last year. Glad to have Senator Wheeler back to present it again.
All right. Thank you, Mr. Chairman. Senate Bill 40 is a bill, as the chairman says, it's familiar to you. I brought this last year, and last year I did have the parents of Micah Chantel Fletcher last year and one of the officers in my town. But what it essentially does, Micah was a young girl, 18 years old. She was looking to attend U-Pike in Pikeville, Kentucky, had gone for a campus visit, and, her parents get a call, every parent's worst nightmare. Their daughter is found dead at the bottom of a stairway. No apparent cause of death whatsoever. No marks on her body. People said it just looks like she laid down and went to sleep. As, of course, a good officer would do, one of our detectives opened a criminal investigation to see what the cause of death was. And also, the body was sent to the state medical examiner. They performed an autopsy, and the cause of death came back as undetermined. Well, Micah's mother was determined to find out what caused her daughter's death. She continued to pursue avenues as to find out what happened to her daughter. She came upon a geneticist at the University of Virginia that recommended a genetic testing of her daughter's blood for abnormalities. They were able to obtain fluids from the department or the state medical examiner. They were sent off, and it was determined that Mike had a congenital heart abnormality that caused her to go into atrial fibrillation, and she died. This condition was something that could have been controlled by a simple beta blocker had she known. The importance of that was that all the other family members were able to go and get tested for this genetic abnormality and determine whether or not that they also suffered the potential for, to simply suddenly drop dead and suffer the same fate. As I said last year, this bill is really more about life than it is about death. What it requires is that young people in a particular category, if the state medical examiner performs an autopsy and the cause of death comes back undetermined, they will send out for genetic testing for cardiac abnormalities. The initial bill last year was a little bit broader. We narrowed it down just for the sake of some costs. The state medical examiner and the coroners, I've met both with them and worked with them to come up with the substitute you see here today, and they're on board with it. Again, this I think not only serves as a way to give families closure, it also allows people, the ones that are left behind, to discover any potential genetic abnormalities that could put their lives at risk as well. So I think it passed out of committee, I believe.
Thank you. Members, we do have a committee substitute in your folders. I'll take that as a motion on the sub if you'd like.
Motion on sub.
Motion, is there a second? Thank you. All those in favor of adopting the sub, please vote by saying aye.
Aye.
Aye. Those opposed? The sub is before us.
Motion on the bill.
Motion and a second from Senator Schickel and second from Senator Turner. Any further questions? Questions of the sponsor? Seeing none. Madam Secretary, please call the roll.
Senator Berg, Senator Carroll,
Aye.
Senator Deneen,
Aye.
Senator Neal, Senator Schickel, Senator Stivers, Senator Storm,
Aye.
Senator Turner, Senator Wheeler,
Aye.
Chairman Westerfield.
Aye. Bill passes with favorable expression. Thank you, Senator, for bringing it back. All right. Senator Carroll, are you ready? While you're coming up to the witness stand there, I want to have everybody welcome the folks from the Leadership Hopkinsville class, which is here. If you're here, raise your hand. So everybody. Like 5 people over here that aren't from the Leadership Hopkinsville class. Thank you. Glad to have you all here. Appreciate you all making the trip up. Hope you enjoy your time up here today. Look forward to speaking with you after the meeting. But I'm glad you all could make it. As a Leadership Hopkinsville graduate in the class that actually built Project Playground, I'm pretty proud of that. But I'm glad to have you all here, and I know you're going to enjoy a lot of what you see and learn today. With that, Senator Carroll and members, we do have a committee sub and a committee amendment that has just been distributed to you.
If we could, go ahead and adopt the committee sub.
Motion on the sub.
Got a motion from Senator Schickel, second from Senator Deneen. All those in favor, please vote by saying aye. Aye. Those opposed? Sub is before us.
Thank you. And Mr. Chairman, within this committee today, you will have the most support you will probably ever have in Frankfort, with all of your folks from home being here. Yeah. Wasn't sure you heard that.
I didn't
Good.
hear all of that.
Purposely. No. Senator Westerfield does an excellent job. I'm just kidding.
And next on the agenda, Senate Bill 6.
I'll learn one of these days. Mr. Chairman, I appreciate the committee hearing this bill today. And Senate Bill 80 is broken up into 2 different sections, and both of them are very brief. I'll cover Section 1 and then bring forth the amendment and then cover Section 2. Section 1 has to do with those who are on the sex offender registry. And within this bill, it adds loitering within 1,000 feet of the clearly defined grounds of a high school, middle school, elementary school, preschool, publicly owned or leased playground, licensed daycare facility, and it adds language, a publicly owned or leased swimming pool or splash pad as defined in KRS 211.205. And that is prohibited unless there is permission from the appropriate body. We had some issues come up yesterday that led us to more clearly define what loitering means. So we added a definition to the bill that basically states that it includes remaining in and or about the clearly defined grounds of a location described in paragraph A, which I just mentioned, of this subsection, while not having any reason or relationship involving custody or responsibility of a minor or any other specific legitimate reason for being there. And I want to add, Mr. Chairman and members, that the measurement in the paragraph of this section shall also be taken in a straight line from the nearest property line. In addition, this prohibition for loitering is not retroactive, so it will not cover any offenses that have already occurred. And Mr. Chairman, we also got to look, and really the main reason I brought this bill forward, within my district, we've had problems in a community with a registered sex offender who operates a food truck pulling right up to the property of a particular park and basically taunting police officers that he has a right to be there. And it has made parents, many, very uncomfortable. And it was the county attorney in this particular county that notified me about this. As a result, I have a Senate committee amendment that it deletes or loitering within 1,000 feet, and it inserts in lieu of loitering within 1,000 feet of or working as the sole proprietor or occupant of any mobile business operating within 1,000 feet. And we have defined mobile business means any business that operates from a motor vehicle or wheeled cart that can be operated, pushed, or pulled on a sidewalk, street, or highway where food, goods, or services are prepared, processed, or sold, or dispensed to the public.
Thank you, Senator. I just was making sure that the committee amendment was written directly to the sub, which we've adopted, and it is.
Yes. And if we can, do you want me to proceed on, or do you want to ask?
Anybody have any questions? Yeah, Senator Storm.
Thank you, Mr. Chairman. Senator, I'd have just one question. I think you may have already clarified this, but yesterday there was an email that was sent from KACDL regarding some concerns, and I believe that that's what you've addressed in the committee subsection 2B2. Is that correct?
That is correct. We look at the current definition of loitering, and the way that was worded really didn't address this circumstance. So we adjusted that definition to an extent, but it will allow for those that are seeking services or going into a courthouse or doing normal daily business, that they would not fall under this if it is a legitimate. There's a legitimate reason for them to be there. So we hope this addresses those concerns.
Thank you.
And I believe that email went to all members, so everybody should have gotten that. And I've also got, I know you want to finish your remarks. Mr. Eklund's here to speak on behalf of his group, and he also sent a letter to all members, but I'll let him speak in just a moment. Go ahead and finish your remarks if you'd like.
Thank you, Mr. Chairman. And Section 2 of the bill is a different topic, and it is related to medical professionals within a healthcare facility. We discovered, and again, I was contacted by some law enforcement officers, prior to 2019, those medical professionals, nurses working within an emergency room were covered under assault third degree. And in 2019, there was a bill that was passed. It was House Bill 106 that passed that year. And as a result of that, and this bill had to do with emergency medical services, there were definitions that were changed in relation to the various types of emergency providers. And it was under legislation or under regulations that were in effect in 2018. It defined an emergency medical services personnel as certified or licensed and trained to provide emergency medical services. It authorized emergency medical services medical director, whether paid or volunteer basis. So under the statute, nurses and those working within an emergency room were covered under this. When the bill was passed in 2019, it changed that language, and it took away the ability for our nurses to be protected within the emergency rooms. It was inadvertent. I spoke with one of the sponsors of the bill, and they did not realize that had actually happened. So the language that we added under KRS 508025, we have added that a health care provider, as defined in KRS 311821, if the event occurs while a healthcare provider is providing medical care within an emergency room of a hospital. So any healthcare provider under that definition that is providing care within an emergency room will be protected under the assault third degree statute. We're not going any further than we were before. We're restoring those protections.
Motion.
Got a motion on the bill. Before we move forward, we need to adopt the amendment, which I don't believe that we've done. Yeah, Senator Turner. Is there a motion to adopt the committee amendment? That's a voice vote, isn't it? All those in favor of adopting the amendment, please vote by saying aye. Aye. Those opposed? Okay. So now the bill as amended by the sub and the amendment. Senator Turner, you've got a question.
Thank you, Mr. Chairman, and Senator, I appreciate what you're doing. As I understand the straight line, and this is only applicable so everybody will know, it's to sex offenders, registered sex offenders. That's correct.
Yes.
And a straight line, 1,000 feet, is that a football field? It's kind of close. And you're talking about a straight line, so if you're on one street, you could be like 2 or 3 streets down, if that's in a straight line.
It is from the edge of the property is how it's defined
I know,
within
but a
statute.
straight line could be
yes.
somebody all the way over on another street.
That is possible, yes, sir.
Okay. I just want the public to know that's. All right,
And
thank you.
and again, it depends. There was never any intent to stop a registered sex offender from crossing these grounds. In that, it's the purpose, and it's to, if they're loitering, they're hanging out, then there are added protections for our kids in those circumstances.
Yeah, I understand that, and I appreciate the bill. Thank you very much, sir.
Thank you, sir.
Any other questions? Senator, I'm going to have George Eklund come up for the Coalition for the
Yes,
Homeless
sir.
and let him speak. I know he sent materials to the members, and it's in your folders, but he wanted to speak, so I wanted to let him come up.
And I'll be very brief about this. So
You're fine, and I don't think you had the chance to see the language that we've just adopted.
No, I haven't.
Right.
So my name is George Eklund. I work as the advocacy director for the Coalition for the Homeless. So we're a 40-member agency in Louisville, Kentucky, with the goal of getting people into housing. We believe that everybody deserves and needs housing, not just for themselves, but also for the community, the good of the community. When people have that stable housing, they're able to seek treatment, they're able to seek employment, they're able to go to therapy appointments, they're able to really become an asset to the community rather than a liability for us. When somebody who is required to be on the registry exits incarceration, they're 2 times more likely to end up homeless because of housing restrictions. We have a small army of caseworkers, of housing case managers that work to put people into housing, but consistently I hear from those providers that people that are on the registry are the hardest to house, mostly because, as you can see from the map that is attached to the letter in your packet, like we have huge no-go zones in Jefferson County where people cannot live. It equates to about 88 square miles, and that's almost the size of Robertson County, which is our smallest county in Kentucky. For us, we see housing as part of the way to promote public safety. When people are housed, we know where they are. We are able to get services to them. We're able to work with case managers to make sure that they're being held accountable in some shape or form. Our fear is that bills like this, and I appreciate Senator Carroll's efforts to get a definition. I look forward to looking at it and kind of reviewing it. But our fear is that this will just perpetuate and make our jobs harder. I would love to assess to see how can we reduce that 1,000-foot barrier to make it accommodate the urban landscape that we're dealing with in Louisville. And then I would also like to have a conversation during the interim of how can we increase in compliance for people that are on the registry who are homeless? Because right now there's not a clear way for them to stay in compliance. So I ask that you table this legislation for this session, and continue this conversation during the interim. And thank you for your time.
Thank you, George. I appreciate that. We got a motion on the bill. Do you have anything else, Senator, you wanted to add?
Mr. Chairman, I was too busy giving you a hard time to introduce myself for the record. I'm Senator Danny Carroll from the Senate 2nd District.
It's a good thing you cleared that up. All right. We got a motion on the bill as amended by the sub and the amendment. And a second from Senator Turner. Thank you. The motion from Senator Wheeler. Any further question? I appreciate the changes you made, Senator. I think that was well done, and I appreciate that. Madam Secretary, please call the roll.
Senator Berg,
Explain my vote? Yes, ma'am. Thank you, sir. First of all, sir, I really, really want to thank you for your intentions behind this bill, and particularly for including healthcare providers and trying to offer them some needed protection, because this is happening now. And unfortunately not just in emergency rooms. I mean, I know this will cover ERs. It will not cover, like my sister who got attacked by a patient at work on the floor, but I really, really appreciate those sentiments. And I also honestly appreciate that we're trying to keep sexual predators away from our children, particularly at places like pools and splash guards where my child spent most of his life growing up. I am concerned about the 1,000 perimeter. You know, I don't want somebody who lives a street away from a school to have to move, even though honestly I would prefer that they not be there to begin with. I'm going to vote yes, but I am going to say that I have serious reservations about the perimeter, and I have serious reservations about who we identify as a loiterer. Because I can promise you, if I'm sitting out there minding my own business, nobody's going to come up and ask me to leave. But there are many, many other people that they will. So I vote yes with some gratitude and some reservations. Thank you, sir.
Senator Carroll,
Aye.
Senator Deneen, Senator Neal, Senator Schickel, Senator Stivers, Senator Storm,
Aye.
Senator Turner,
Can I explain my vote, Mr. Chairman?
Yes, sir, you can.
Thank you, Mr. Chairman. I believe that the 1,000-foot would not apply to somebody that lives in a residence. It says loitering, and they can do what they want to around their residence. As a lawyer, I don't see how it would be applicable that anybody could be charged with loitering when it's your house, your outside playground, your outside street you're on. That's not loitering. That's where you live. So I'm voting yes for this bill.
Senator Wheeler,
Aye.
Chairman Westerfield.
Aye. Bill passes with favorable expression. Congratulations, Senator. And I believe you do not want to roll the amendment into the sub.
I do not. May I make a quick comment
Yes, sir.
to clarify something? The addition of the swimming pools and splash pads is not part of residing. We didn't add to that. It's only loitering. So there's no additional pressures as far as where your residence is.
Yes, ma'am.
Question then?
Yeah, that's fine.
So if I'm a registered sex offender and I live across the street from the school, and
You can't live across the street
I
from
live
the school
1,000
already.
yards from the school, and I'm sitting in my front yard watching the kids come and go, I'm free. There's nothing you can do to me.
If you are past that 1,000 foot,
What if I live within it?
you can't live within
You
it.
already can't.
Already
You are
can't.
offending if you live within
Thank you.
1,000 feet.
Affirms my yes vote. Thank you very much.
Thank you, Mr. Chairman. Thank you, members of the committee.
Thank you, Senator. Nice job. While we're waiting, I want to, for all the leadership items of folks, to explain everything that just happened. You got a little exercise in the committee amendment process, which we rarely do. We do committee substitutes, which is also a way to amend a bill in the committee. And I won't get into the details because that'd bore everybody. But you've just seen exactly what the legislative process is intended to do. A sponsor files a bill that came from a constituent basis and a need from his district. Worked on the bill, filed it. Issues were raised that were legitimate, and changes were made. And those changes were adopted just now through both a committee substitute and a committee amendment. But both of those are ways to amend the original bill while it's still in committee. That's how the process is supposed to work, and I'm really excited that you all got to see that.
And my favorite chairman allowed me to present the bill.
Yeah. I'm not going to comment on that. Are we ready on Senate Bill 9? Please distribute that committee substitute, if you can, Roberta and Randall. Again, members, this is a bill that you heard back in the interim, I think in our very first meeting in 2022. Senator Mills and Representative, glad to have you both here. Senator, you have the floor. Representative.
Thank you, Mr. Chairman. I'll just explain real quick. The sub that's being handed out are some minor changes that Senator Wester, the chairman, Westerfeld, and myself worked on, and had some input, and there was just some minor glitch. We didn't get it out in time, so I appreciate it.
Disaster averted.
It is a disaster averted for sure.
Got a motion. Is there a second? Thank you from Senator Schickel and Senator Wheeler. All those in favor of adopting the sub, please vote by saying aye. Aye. Those opposed? The sub is before us, Senator.
Perfect. Well, today before you is Tracy and Kirk Hazelwood and Representative Jonathan Dixon. We are Henderson. We are Lofton's Law, and have been involved in advocating for change in this particular law for the last year or so. I'm going to yield for a few minutes here to allow Tracy to tell Lofton's story in a summary form, and to say a few comments, and then I'll have a few comments after her.
Well, I know you all heard my story back in October, but for you guys that didn't, I'll just give a short story here. My son, Lofton Hazelwood, left for the University of Kentucky in August of 21. And he pledged a fraternity, and he got a bid for the farmhouse in Lexington. He was thrilled to death. I mean, it was just a bunch of good old boys and all this. So after he got his pledge card, everything kind of changed. There were different things they had to do that they didn't necessarily want to do. Some things that were illegal, could have kicked him out of school, things that we didn't find out until afterwards. But on the night that Lofton passed away, they were supposed to go serenading that night. And they were told that it was a tradition to drink Wild Turkey 101. My son's blood alcohol was 0.354. He had drank so much that he couldn't walk, and they took him up to a bedroom upstairs and left him by himself. And they all left to go serenading. It was like almost an hour later, a young man came into the house and found him. And it was just too late. It was just too late. But they said that it was tradition that they were to drink this Wild Turkey. Now, what Senate Bill 9 is all about is about hazing. Hazing is a specific form of abuse that is not adequately covered in the state of Kentucky. Everything is left up to the universities. We have had so much support in our area, and I want everybody to know how much I have appreciated the people that are behind us. We've talked to people all over the country that have gone through the same things. There are only 13 states that actually have a law. I have a stack, and I know you guys got all these. I have a stack of emails from the junior high kids in our hometown. Senate Bill 9 will send a message that Kentucky values student safety. And Senate Bill 9 will hold people accountable, especially those responsible for serious bodily harm or death, as in Lofton's case. We beg of you to pass this law because we don't want anybody to go through what we went through. I want everybody to think about being 3 hours away and you get that phone call. So just please consider it. Thank you.
Mr. Chairman, currently Kentucky law places the burden on universities and colleges to enforce the act of hazing with the maximum penalty of expulsion of the student. Senate Bill 9 seeks to add Kentucky to a list of 13 other states, as Tracy said, that will elevate this act of hazing to a criminal status. For far too long, hazing has been this awkward rite of passage in Kentucky and other states that many still refuse to acknowledge as wrong. We believe that the elevation of hazing to a crime addresses head-on the seriousness of these actions. It lets students know that Kentucky values student safety. Let me say that again. Kentucky values student safety, and any violations of their safety will be addressed. We do not believe that the wanton endangerment charge in Kentucky adequately covers all the acts of hazing, and this is why it merits a separate criminal status. Under Senate Bill 9, a person is guilty of hazing in the first degree when he or she intentionally or wantonly engages in the act of hazing that results in the serious physical injury or death of a student. Under this proposed legislation, first-degree hazing will be a Class D felony. Under Senate Bill 9, a person is guilty of hazing in the second degree when he or she recklessly engages in the act of hazing, and under this legislation, second-degree hazing will be a Class A misdemeanor. And finally, in Section 1 of the bill, it thoroughly describes what hazing is, gives a good definition so there's not any confusion. And as Tracy said, and as you've seen in your inbox, your email inbox, there's support all across the state, even outside of Northwest Kentucky. There's support for this legislation. We're hopeful that that future Kentucky students will not have to endure the needless hazing to join an organization, and we truly believe that this law will save lives of future Kentucky students. So with that, Mr. Chairman, I'd be open to comments or questions. I'll be happy to explain the small changes that we made in the sub if you'd like for me to.
Members, are there any questions? Yeah, Senator Schickle.
Thank you, Mr. Chairman. And first, I want to give my condolences to your family in this horrible tragedy. And our hearts go out to you. It's a shame the Senate President isn't here, because normally he asks this kind of question that I'm going to ask, and that is, in the criminal investigation that was done on this death, was there something in this hazing, this proposed hazing law? Because as I look over the what's prohibited, it appears to me that it is a current law. It's just not put in with hazing. Is there any additional law besides the laws that we already have on the books?
Well, specifically, the law that we have on the books is just pertains to colleges within the college ranks, that they can expel the student. There's no criminal charge of that unless you go down the path of wanton endangerment. And that's what I was saying in my comments, is that hazing is much more comprehensive, and sometimes the wanton endangerment charge does not apply specifically to some of the hazing that occurs. When you're talking about having a student sit on the wall for 6 hours in wall sits, or having somebody come and pick you up at a restaurant at 4 in the morning when you have a test at 6 in the morning. Those are things that that is hazing that occurs. The wanton endangerment might catch if you're throwing something at somebody or something that fits wanton endangerment, but that hazing is much larger than wanton endangerment. Does that answer your question?
It does, and it doesn't. I think it's a matter of what a prosecutor and how vigilant a prosecutor wants to be. And
right.
I remember the Senate President always used to say, "A lazy prosecutor bill." The prosecutor in the community has to sort this thing out and go through it and find, because from everything I could see in this, the offenses were in there, the crimes were in there in current law.
And I think the other part of this is truthfully elevating this occurrence, this action, to keep it from happening again. I think it's at a point, if you talk to college students around, there's a recent article that was written by the Lantern that actually showed how tough it is to get a comment on this, but when people actually comment on it, the students say there needs to be a stick behind hazing to make it to where you can stand up in the training that some of these organizations go through and just say, look, we're serious, Kentucky's serious about this, have fun, but don't haze. And I think that's the intent of this law.
I think it accomplishes that. They know what hazing is. They don't know what wanton endangerment first
That's
degree
right.
is.
That's the issue.
You can in just a moment. I also want to highlight something in your bill, which I think might address that. There's also been concerns. Anytime we create a new criminal offense, people are concerned about there being another crime that people can have on their record at some point. But the bill actually cleverly addresses that with wanton endangerment, allowing the times to run concurrently with one another.
Yes.
So you can't stack that up.
Correct.
It addresses where you've got situations that one offense might cover one and might not cover the other, or might cover both in this case, but you can't run the time back to back.
Correct.
Your follow up, and then Senator Turner's got a question.
Thank you. Well, he hadn't, let him go. He hasn't done anything. Go ahead.
Okay, Senator Turner.
Thank you, Mr. Chairman. I'm not Mr. President of the Senate, but I think Section 2 clearly clarifies the question: a person is guilty of hazing in the first degree when he or she intentionally, wantonly engages in the act that results in serious physical injury. You can't say that, well, I encouraged him to, but I didn't do it. And if a person is 18 years or older, you can, as a adult, maybe is the same age or older in one of those units, keep convincing them that they need to drink. This prohibits that.
Yeah.
Because the engagement in that conduct will get you found guilty of a Class D felony, which is 1 to 5 years in the penitentiary.
That's right.
Now, if you're just encouraging, down in the second provision, you're guilty of hazing the second degree when you recklessly engage in that. So it's very clear here, the prosecutor won't have no choice.
That's right.
If somebody's injured, they're going to get charged with that offense, one of the two of them. It's just the degree that they play in the encouragement or actual participation of it.
Correct.
It's very clear as a
Correct.
fellow that's practiced criminal law for 40 years plus.
Senator Turner, we that was one of the changes in the sub, is that we changed from participation to engage.
Yes.
Yes. Senator Byrd.
Thank you, Mr. Chairman.
Yes, sir.
Thank you, Mr. Chairman. I want to look you both as best I can in the eye and say thank you for your courage in being here. I have recently learned how hard it is to speak for a dead child and how much of you it takes to come up here and do this, and I applaud your willingness to do this, and I thank you for your efforts to protect other children. Hazing is a problem. It is a big problem. My child, in his fraternity, actually accepted the job of being the one to go and learn from National exactly what the rules were, and to make sure that they were applied to the best of his ability at his fraternity. And we talked about this, and we talked about the importance of this, and that people can die. So, sir, I applaud your legislation. I applaud your bravery, and I am so sorry for your loss. Thank you.
Senator Deneen.
Thank you, Mr. Chairman. I'd like to start off by again reiterating what many have said up here. We are sorry for your loss. As a former educator, retired educator, this hits home for me, as we're entrusted with the most valuable assets that we have in Kentucky as educators. Our parents give us their children for most of the day, and as they go into university for a period of 4 years and sometimes longer. It is our responsibility to do all we can to instill that trust and awareness of the value that they are putting in our hands as educators. I am grateful for your efforts, Senator, for this bill. This goes to the very heart of what I'm speaking of, and that is the entrustment of one's children. So thank you for the bill. It has my full support.
Thank you.
Senator Storm for the final question on this bill.
Thank you, Mr. Chairman. Senator, I want to ask you about Section 2 and 3. And in Section 3, it talks about defenses that are enumerated there. I think it's section 3, subsection 3. You see that on page 2?
Yes.
So those defenses are enumerated in the statute for reckless conduct, but there are no defenses listed in section 2. And I just wanted to see if you could explain if there was a thought process about that, or if that was an oversight or if that was intentional.
Maybe an oversight. Maybe an oversight. I'm not sure.
May I have a follow-up? And that may have been something that Senator Turner mentioned previously about wanton conduct versus reckless conduct, but would you be willing to talk with me about that?
Absolutely.
Thank you.
I would. Thank you for pointing that out.
See no further questions. Just make sure. All right. Do we have a motion? We've got the sub adopted. We've got a motion from Senator Turner and a second from Senator Wheeler, I believe. Any further question or comment? Seeing none, Madam Secretary, please call the roll.
Senator Byrd,
Aye.
Senator Carroll,
Aye.
Senator Deneen, Senator Neal, Senator Schickel, Senator Stivers, Senator Storm,
Cast my vote and explain.
Yes, sir.
Cast an aye vote today, and based upon my comments, I look forward to working with you on this. Thank you.
Senator Turner, Senator Wheeler,
Aye.
Chairman Westerfield.
Thank you, Mr. Chairman. I'd like to express my thanks to the LRC staff for helping today
Yes,
too
sir.
as well. Thank you, Roberta.
Thank you, Senator. Thank you, Representative. Thank you both. Yes, ma'am. Our next bill, our last bill, Senate Bill 63, is mine, so I'm going to head on down.
Senator Westerfield, if you and your guests could introduce yourselves.
Thank you, Chairman. Whitney Westerfield, Senator for the 3rd Senate District and sponsor of Senate Bill 63.
I'm Jariah McMillan.
I'm Jackie McGranahan with the ACLU of Kentucky.
Okay. You may proceed, sir.
Thank you. I'm here for Senate Bill 63, which is commonly known as the Crown Act, a bill that many of you, if not most of you, have heard before. We've heard testimony on in the interim before and before other committees. And I can't take credit for this idea. Former Representative Atticus Scott, who I was hoping would be here this morning with us, was the first to file it down in the House. Others have filed it, and I believe there's a bill pending in the House right now on this. But it does two very simple things. It makes two very modest changes to our Civil Rights Act by adding the definition of protective hairstyles and the definition or explanation of the term race. And then it changes in Chapter 158, which relates to the conduct of schools. It provides for the prohibition of discrimination on the basis of race as defined in the Civil Rights Act, which is amended by Section 1 of the Act. I've talked more and said more words than there are in this bill that are new. But the import of the bill is far more significant than the number of words that are in it. It protects hairstyles. It protects the individual dignity, particularly of students. That's why I'm glad I've got a student with me here today. And he's, by the way, on behalf here of a group called the Real Young Prodigies, who you've also probably heard from. They've been in our committee a number of times before and other committees. And they've been champions of this long before I got involved. But I think it's important, and Jariah can talk about his perspective if he'd like to, but I think it's important to provide these protections for students in particular. If they've got hairstyles that are ethnically appropriate for themselves and what they want to have and what their hair is, and they shouldn't be discriminated against because of their hair. They shouldn't be forced to cut their hair. They shouldn't be forced to make changes just to address the hair that they've got. because of the way that it is, because it doesn't look like mine or yours, Mr. Chairman. And as the father of two biracial children who this may impact one day, it's important to me. And so I wanted to bring the bill before the committee this morning. Jariah, you want to say anything?
Again, I am Jariah McMillan, and before I get started talking, I would like to thank Carol, Senator Carol, for co-sponsoring the bill. I would also like to thank Chairman Westerfield and the Judiciary Committee for this honorable opportunity to speak to y'all today. So I want to start this off by saying, do any of y'all have any younger siblings? I do. So, as them being our younger siblings, we all know that they could get on our nerves sometimes. We also know that as being the older sibling, we want to protect them. And we must protect them, even if they don't want our protection. And that's why I'm here today. I'm here to protect my younger sibling, D'Angela McMillan. This is her. As y'all see, she's wearing her fro, which she likes to wear a lot. She has red hair. And my sister has been bullied because of her hair. She has constantly been bullied by kids coming up to her and telling her that, oh, she got lice in her hair. She got all that hair and her curls, she must got lice in her hair. And she had came home complaining about it, and she cried because of it. She also been discriminated against her hair. People that we don't even know have came up to her and grabbed and touched her hair without her permission. We don't know these people at all. They just came up and decided to grab her hair for some reason. And then also, her step coach, she had told my sister that she cannot be on the step team unless she has a slick back ponytail. And when my sister had told me all of this, I told her that we got to stand up. This goes against the ordinance that we have passed in Louisville, which is creating a respectful and open world for natural hair, which you could wear your hair without being discriminated by. And as Kentuckians, we should want to protect each other. That means, my fault. That means even if wearing your afro like my sister, or wearing your mullets like the Meade County baseball team did before they was forced to cut off their mullets. And we have to come together. Now, if y'all will, can y'all please repeat after me? United we stand.
United we stand.
Divided we fall.
Divided we fall.
That's our motto. Thank you.
Nicely done.
Hello, members of the Judiciary Committee. My name is Jackie McGranahan, and I'm a policy strategist with the ACLU of Kentucky. Thank you for allowing me the opportunity to testify today. And, of course, my deepest appreciation to the sponsor of this measure, Senator Whitney Westerfield, and his consistent support of measures impacting racial justice. And also, thank you, Senator Carroll. CROWN, as Jariah said, is an acronym for Creating a Respectful and Open World for Natural Hair. This law was first introduced in California in 2019, and the first CROWN Act expanded the definition of race in the Fair Employment and Housing Act and the State Education Code to ensure protection from discrimination in workplace or schools. Historically, hair discrimination has been rooted in different standards of beauty, and that sometimes black hairstyles can be viewed as unprofessional or unkempt. And this bill would not affect, if there's a law requiring everyone to wear hairnets, then this isn't what we're talking about. This is only in regards to singling out a black student or employee for a different reason than other employees. So hair discrimination is a real issue, and ensuring these protections are in place for all Kentuckians is a step in the right direction towards preventing and eliminating discrimination for any reason. And many Kentucky communities have passed local ordinances, including Covington and Louisville, and this bill passed in Tennessee. So we're hoping that Kentucky can be the next state to pass this legislation. And of course, thank you all again for allowing us to testify. And we urge you to vote yes.
I didn't know it protected mullets.
I believe Senator Turner had a question.
Thank you, Mr. Thank you, Mr. Chairman. And so that I don't sound anything but normal, I'll tell you who I am. I'm my great-great-grandmother was full Cherokee Indian. I'm married to a Panamanian. So just get that out on the table, who I am and what have you. I have biracial children also. And they're, one's real white and the other one was more, he got people walk up to him and say, Sam Bowie, can you sign my autograph? Okay. But the real question I have is just what she alluded to, Mr. Chairman, Senator now down there. But I worked in the factories where you couldn't have long hair. You had to have short hair because you had machinery above you that would twirl and go. And I just want to make sure that that won't be impacted. I also worked at a burger chef restaurant before I got drafted in the Army, where you had to have certain things. And I just want to make sure, because this, as a lawyer, this is very straightforward, and I don't know how it will impact, if any, that part of the workforce. That's all I'm really inquiring about, that the workforce where companies have certain rules or institutions have certain rules for protection, whether it's athletics or whatever. Because some athletics is going to involve where you're around certain machinery that might get you hurt if your hair is long. My daddy offered when mine was long, and I was not quite as long as his, but something like that. But I had a big beard and all that. Me and 6 brothers, he offered us all $1,000 apiece to go get that all cut off. But we didn't. And that was back in early 70s, late 60s and early 70s, when I got out of the Army. So that's the question I have, is anybody checked about this language being interpreted wrongfully to cause that business organization, company, which is required,
yes, sir,
sometimes under workers' compensation laws, to provide a safe place of employment, do all what's necessary. I just don't want any problem there.
I understand.
Okay.
This does not prohibit or inhibit a company from maintaining safety standards or anything else that it would ordinarily have to do. And there have been no cases that I'm aware of in any other jurisdiction that has passed this, red state, blue state, purple state, of any kind, where those sorts of cases have created a problem.
Thank you, Mr. Chairman. I did that for the world out there, the business world that may hear this and have some questions.
Yes, sir.
So it's on the record now that they can see. Thank you, Mr. Chairman.
Senator Schickel.
Thank you, thank you, Mr. Chairman. Is this just for schools, or is this schools, employment, anywhere?
I think it's for everyone, everywhere, but the second section of the bill makes it apply directly to schools as well. I mean, we're changing the Civil Rights Act, so that's there, but the discrimination language specifically relates to Chapter 158, which is the conduct of schools.
So if if a school had a varsity football team, and on the varsity football team all the young men were required to have crew cuts on that varsity football team, certain students could be made an exception to that under this?
I would say so.
Okay.
I'd say requiring them all to have the same haircut would be a problem.
Okay. In the jails and prisons I've run over the years, we had haircut requirements for certain units. Honor units would all have their haircut real short. They had more privileges. That would be a problem as far as that's concerned.
I would think so.
Okay. What if a white student, or let's say a non-black student, had long hair? Would they have the same protection?
Yes, sir.
Can I speak on that?
Yes, sir.
This ordinance is for everybody. Like I said before, the Meade County baseball team, they all had mullets. All of them was white. They was forced to cut off all their mullets. Their mullets was a way of showing their bond and their connection with each other. And they was forced to cut it off. They either cut it off or they didn't, and they couldn't play a season. So they cut off their mullets. But their mullets was a way of showing as a team that we're in this together, and this is our bond. And this is how we're going to bond. They all chose to get mullets, and they was all forced to cut them off.
And I thank you for sharing that with me. We just disagree, and that's why I can't support this legislation. Down through history, sports, all kinds, uniforms, all kinds of situations where haircuts and uniformity have been used in a traditional way to for all kinds of things that make units better, not worse. So I just don't understand the motivations of it. It would seem to me that if it does apply to everyone, then that means there can be no rules if it applies to everyone. So for that reason, I can't support it.
Senator Neal.
Thank you, Mr. Chairman. First of all, I want to thank you, Senator Westerfield, for bringing this legislation. And before us, I want to thank our guests from stepping forward. I know you've stepped forward on a number of occasions, and various individuals have appeared before us in one capacity or another to deal with this issue. I just wanted to, this is not a question, Mr. Chairman. This is more of a observation and a comment. You know, I think you can't look at something like this in just a silo. You have to understand that we are, as a society, evolving, and we do have a history that is manifesting itself each and every day. And because of that, and without attention, such as being offered here, this is my opinion, then you don't have an opportunity to reaffirm individual dignity and respect. Because at the end of the day, it gets down to that confirmation of the individual and how they regard themselves. So I do understand some of the concerns if it's safety involved. I understand that that issue would have to be dealt with in the context of safety. But sometimes what we do as society is that we, particularly majority to those who are not in the majority in that society, we impose our image and our determination as to what is good, bad, what's beautiful, and what's not. And even subconsciously we do it. It's not like someone's running around necessarily trying to be angry or mad at somebody. So I think this brings this to the fore, gives us an ability to reaffirm the dignity and respect that each individual is due in our society. And I want to congratulate you for bringing this forward. And hopefully it'll pass, but I urge everyone to support this legislation. Thank you, Mr. President.
Senator Burke.
Thank you, Mr. Chairman. Senator, thank you for bringing this bill. And, sir, thank you for coming up here and speaking for your sister. You know, this discussion this morning is reminding me, unfortunately, of what they did, honestly, to Jews in the Holocaust. The first thing that happened to you when you showed up at a camp was they shaved your head. I don't care if you were a man, I don't care if you were a woman, I don't care if you were a child. They shaved your head, and they did that to dehumanize you. We do not live in that society. We will not tolerate that in our society. And, sir, you have the right to be the human you were born to be. And I am so happy to be able to stand up here and say yes. So thank you.
Senator Storm.
Just had a very quick question. Would this pertain to individuals in the military like Kentucky National Guard or Kentucky State Police or anything of that nature? How would that work if you've thought about that?
Senator, I don't know the answer to that question. My first gut reaction, unless Jackie's got an answer from other states' experience, my first reaction is that they have to abide by their own set of rules, the Code of Military Justice or other installation standards and various. My instinct is that it would not apply to them, but I can't say that I've researched that or had anyone on staff look into that. I can try to get an answer to that question for you that's more concrete than my gut, but that's all I've got right now.
Thank you.
Yes, sir.
I guess I'll take a privilege of asking a question myself. So
yes, sir.
You say this applies to everybody, right?
Yes, sir.
So if my secretary decided to come in tomorrow with a pink spike do into the office and, you know, wearing a shirt that says F you and, you know, really, which I know my secretary would never do that, but if she did, could I say, you need to this is not the image I want to present for my business. You need to come in with, a more traditional look and a professional look, just similar to the dress code that we adopted on the Senate floor.
So the shirt, this bill doesn't speak to in your fact
Yeah.
pattern there. So I can't speak to the shirt. But as the employer, I assume you might be able to impose a dress code for your office. But again, that's not related to this bill. The hairstyle, if she were to come in with a hairstyle that was her natural hair, I'm not sure if the pink would qualify here or like a mohawk or something, if that's what she wanted to have, that sort of hairdo. But this protects hair, including protective hairstyles, and looking at the language, protective hairstyles includes, and these are just examples, it's not limited to this, braids, locks, and twists, but that they are historically associated with race, including but not limited to hair texture and protective hairstyles like locks and twists and braids. So if she could make the case that was historically associated with her race, then I'd say she would be protected, and you'd have to offer her some sort of reasonable accommodation. Outside of that, I think you could probably impose standards.
Okay. I mean, I guess supposedly, I guess she had Irish heritage, and if you ever watched the movie Druids, there's some pretty wild dudes. So she could come in there and argue something like that.
Well, she can't. Would be in regards to instances. If you have a rule in your office that we have to look professional, and this rule applies to everyone, and it's not being used as a proxy for just black people, then absolutely not. Like, you can have rules that we have to be professional. And of course, they could file the complaint to the commission, and then they would determine from there, is this discriminate, or is
the applied rule?
Yeah.
Okay.
Is the
course, if they
Wheeler
have
Law Office being discriminatory?
Sure. I mean, but I guess if you had an African American working there, that would probably imply that you didn't have a problem with African Americans working there just by the fact that they're present, would it not? I mean, just, all right, I guess, do you have a motion? Okay, all right, I guess, yeah, do we need anybody want to make a motion on the bill? Second? Okay. Have a motion by Senator Schickel and a second by Senator Berg. Madam Clerk, please call the roll.
Senator Berg,
Aye.
Senator Carroll,
Aye.
Senator Deneen, Senator Neal, Senator Schickel, Senator Stivers, Senator Storm,
Cast my vote and explain.
Absolutely.
Thank you. I'm going to vote aye. This is a legislative process, as you pointed out earlier, and did ask those questions about the National Guard and Kentucky State Police. I would like to have those resolved, but for today's purpose, I vote aye.
Yes, sir. Thank you.
Senator Turner,
Yes, sir. Go ahead.
I'm going to vote aye to get it out of this committee, but in response to Wheeler's questions, I understood he said all the baseball players are white. It's not a color thing. That's the problem I have with this. Acceptable and not acceptable. So I'll vote to get it out of committee, but I really think we need to make some tightening up of the statutory to not cause a problem.
Thank you.
Senator Wheeler,
No.
Chairman Westerfield.
Aye. I lost count, Chairman.
6-3 passes with favorable expression.
Thank you, Chairman. Members, thank you so much.
Do I have a motion to adjourn?
So move.
All right, we're adjourned.